The other party didn't answer. Unlawful detain of judgment by club. But we need some hearing. The other party didn't answer, just by default. After court trial, if not, by court. Judgment by court. How you can come to one team? Okay. Possession only, meaning for just a vacant house. Do not fight, just the default. Possession only. Defendant did not appear at trial, meaning it's the same thing. Defendant did not appear at trial. That's the judgment. Just you can choose one of them. Normally by court, by judge. By club, by court. Page 17. 17 pages. Number one, by default, defendant was properly served with a copy of the summons and complaint. Defendant was properly served. Defendant served. Was served, meaning received, with a copy of summons and complaint. Defendant receiving copy of summons and complaint. Even after receiving the document, didn't answer. This means by default. B. Defendant failed to answer the complaint or appear and defend the amount with the time allowed by law. Same meaning, defendant failed to answer, didn't answer to complain or appear the defendant defend the action with the time allowed by law. C. Defendant default was entered by the club upon plaintiff's application. D. Clerk's judgment for possession only of the premise described on page 2. This meaning for the just possession only. My house just refund to me. That's all. I didn't answer. I don't requested any. My house just refund to me. E. Court judgment. The court considered number one, plaintiff's testimony and other evidence. 2. Plaintiff's or others written declaration and evidence. Number 2, at the court trial, the jury was weighed. The court considered the evidence. A. The case was tried on date and time before name of judicial official. B. Appears by plaintiffs, name each. Plaintiff's attorney, name each 1 and 2. Continued on attachment to B. Time MC 025. Defendant name each. which meaning if the defendant moving for any rent, he call any other person, relative. In case, if not named on the paper, they cannot move in. That's a reason for. Next one, continue on that attachment 2B. Defendant name each, defendant attorney name each. Continue the attachment. C. Defendant did not appear at trial. Defendant was properly served with the notice of trial. The statement of decision, Code of Civil Procedure, 632. Attachment of the defendant was recast. That's the page. Page 18. Judgment is entered as followed by the court, the clerk. This meaning the judge by court meaning by judge, not clerk. Judgment, judge. 3 parties, judgment is A for plaintiffs, name each. Is against the defendant, name each. Continued on attachment 3A, form MC 025. B for defendant. 4 the party entitled to possession of the premises located street address apartment by city and county. Plaintiff's name in item 3A. Defendant name in item 3B. Defendant list on attached from UD 110P in item 8B1. 5. Judgment applied to all occupants of the premise, including tenants, subtenant if any, and named defendant if any. The name claim. 6. Amount and terms of judgment. 8. Defendant named in item 3A above name must pay defendant plaintiffs on the complaint. Right side B. Plaintiffs is to service receive nothing from defendant name in item 3B. Defendant named in item 3B to recover costs and attorney fee cost. Number 1, past due rent, didn't pay the rent. 2, holdover damaging. Damages, some broken or some dog and cat as they are dirty, didn't, they need some cleanup. Attorney fee, cost, are the total judgment. C. The rental agreement is cancelled. The The lease is forfeited. Seven. Conditional judgment. Conditional judgment meaning plaintiff has to have breached the judgment to provide habitable place to defendant as a state in judgment. Unlawful detained habitable place. A judgment for partial eviction. A partial eviction is issued as a state in judgment. Unlawful detained partial eviction attachment, which is attached. Number 9, other specified. Contained attachment 9. Date. Judicial officer meaning judgment. Who make the judgment? Judge or clerk. The bottom date, clerk. By who? Deputy. Next page. Next one is page 19. Answer. Former one is didn't answer. Didn't answer is he getting the plaintiffs get the judgment. But the other party's answer. If the other party's answer, in case they should do at the hearing judgment. 19. If somebody getting for the unlawful detainer summon, just answer after 1 month getting hearing, and then we get the more the time. On the top portion is same thing. Number 19, page 19, answer unlawful detainer. Defendant. All defendant for whom this answer is filed must be named and must sign this answer unless their attorney signs. Answer to the complaint as follows. Number 2, denier. Check only one of the name 2 box. Check only one of the name 2 box. 8, general denier. General denier meaning all of them is I denier. Do not check this box if the complaint demands more than $1,000. Because the amount is more than $1,000, general denier do not check. Defendant generally denies from each statement of the complaint and the mandatory cover sheet and the supplemental allegation unlawful detainer. B, specific denier. A meaning general denier. B, specific denier. Specific denier is the some reason, some portion is the reason they have. Check this box and the complaint number 1 and number 2 below if complaint demand more than $1,000. Defendants admit that all the statement of the complaint and of mandatory cover sheet and the supplemental allegation unlawful detainer are to accept. Number one, denial of allegation in complaint from UD 100 or other complaint for unlawful detainer. A defendant claims the following statement
Yes.
of the complaint and the phrase statement of paragraph. State paragraph number from the complaint or explain below, or if more room needed on form MC-025. Explanation is on form MC-025, filed as attachment to B 1A. B. Defendant has no information or belief that the following statement of the complaint are true. So defendant denied them. State paragraph number from the complaint or complaint below. Two, denial of allegation of mandatory cover sheet and the supplemental allegation unlawful detainer. A. Defendant did not receive plaintiff's mandatory cover sheet and the supplemental allegation. Form UD 101. 101 meaning is the answer. If not checked, complaint A as appropriate. B. Defendant claims the following statement on mandatory cover sheet and the supplemental allegation. Unlawful detainer. Form UD 101 are false state paragraph number from form UD 101 or explain below, or if more room needed, explanation is on form MC-025, titled as attachment 2B. Next page, page 20. 2B, 2C. Defendant has no information or belief that the following statement of mandatory cover sheet and the supplemental allegation unlawful detainer form UD 101 are true. So defendant denies them. State paragraph number from form UD 101 or explain below, or if more room needed on form MC-025. Explanation is on form MC-025, titled as attachment. Three, defendant and objection. Note: for each box checked, you must state brief fact to support it in item 3T, on page 3, or if more rooms in needed, on form MC025. You can learn more about bee defense and objection at www.court.ca.gov. Please self-help. If you go to this section, www.court.ca.gov, self-help. If you go this place, you can get all the form C, and then you can handle without the attorney all the case, you can do it. 3. Defense and objection. Note: for each box checked, you must state with fact to support it in item 3T, on page 3, or if more than is needed, on forms MC025. You can learn more about defense and objection at www.coach.cag.gov/self-help. Self-help. 8. Non-payment of rent only. Rent and non-payment, didn't pay to the rent. In case marked here, plaintiffs had breached the warranty to provide habitable premise. B. Non-payment of rent only, same one. Defendant made needed repair and properly deducted the cost from the rent, and the plaintiffs did not give proper credit. A section is just plaintiff's problem, plaintiff is wrong. He breached the warranty to provide the habitual premise. B, meaning did not pay. That's the problem, is from the defendant. C, non-payment of the rent. C, non-payment of rent only on date before the notice to pay or quit expired. Defendant offered the rent due, but plaintiffs would not accept it. D, non-payment of rent only. Plaintiff's demand for possession is based on non-payment of rent due more than 1 year ago. Due more than 1 year ago. E, plaintiffs waived, changed, or canceled the notice to quit. F, plaintiff served the defendant with the notice to quit or file the complaint retaliate against defendant. e.g. by serving defendant with the notice to quit or filing the complaint. Plaintiffs arbitrarily discriminating against the defendant in violation of the Constitution of the laws of the United States or California. Page 20 and center line is H. Plaintiffs defend for possession violate the local rent control or eviction control ordinance of city or county, title of ordinance, and date of possession. Also, define the state in item number I. Plaintiff's demand for possession is subject to the Tenant Protection Act of 2019, Civil Code Section 1946.2 or 1947.12, and is not in compliance with the Act. Check all that apply and briefly state in item 3T the fact that support each. I. Plaintiffs failed to state a just cause for termination of tenancy in the written notice of terminate. 2. Plaintiffs failed to provide an opportunity to cure any other violation of terms and conditions of the lease other than payment of rent as required under Civil Code Section 1946.2. 3. Plaintiffs failed to comply with the relocation assistance requirement of Civil Code Section 1946.2D. Number 4. Plaintiffs has raised plaintiffs failed to comply with the relocation assistance requirement of Civil Code Section 1946.2. 4. Plaintiffs has raised the rent more than the amount allowed under Civil Code Section 1947.12, and the only unpaid rent is unauthorized amount. Number 5. Plaintiffs violated the Tenant Protection Act is another manner that detailed the complaint. J. You don't have any books?
I have it, I forgot it in a different car, sorry.
Okay. J. Plaintiffs accepted the rent from defendant to cover a period of time after the date the notice of quit expired. K. Plaintiff seeks to evict defendant based on an act against defendant. Defendant's immediate family number or a number of defendants houses hold that constitute domestic violence, sexual assault, stalking, human trafficking, abuse of an elder or a defendant adult, or a crime that caused bodily injury, involve deadly weapon, or use to force or threat of force. This defense requires one of the following, which may be included with this form. Number one, temporary restraining order, protection order, or police report. That is not more than to sign the statement form of qualified third party. Example, doctor, domestic violence or sexual assault counselor, human trafficking casework, psychologist, or a victim of violent crime, advocate, counseling in the injury of abuse resulting from these acts. Another form of documentation or evidence that will apply that the abuse or violence occurs. Number one, the abuse or violence was committed by a person who does not live in the dwelling unit. Two, the abuse or violence was committed by a person who lives in the dwelling unit, and defendant claims protection from eviction on the Code of Civil Procedure, is section 1161.3 DG. J. Plaintiff seeks to evict defendant based on the who does not live in the dwelling unit. Number two, the abuse or violence was committed by a person who lives in the dwelling unit, and defendant claims protection from eviction under Code of Civil Procedure, section 1161.3 DG. B2. I. Plaintiff seeks to evict defendant based on the defendant on or another person calling the police or emergency assistance, example, ambulance, by or on behalf of the victim of abuse, a victim of crime, or on individual in an emergency when defendant or the only person believed that assistance was necessary, and plaintiff's demand or possession of a residential Plaintiff's demands the possession of a residential property is based on non-payment of rent or other financial obligation and check all that apply. Number one, plaintiff received or has a pending application for rental assistance from a governmental rental assistance program or some other source relating to the amount claimed in the notice to pay rent or PIT. Next, page 21. We go to the break-on, go to the restroom. If you don't have any books, go to the office. Just today only, make the copy. From the 21 to 22, 23. Okay, page 21. Answer for the payment. Number 3, M. Plaintiff received or has a pending application for rental assistance from a governmental rental assistance program or some other source for rent occurring since in the to the notice to pay rent or quit. 3. Plaintiff's demand for possession is based only on late fee for defendant failure to provide landlord payment within 15 days of receiving governmental rental assistance. And plaintiffs violate the COVID-19 Tenant Relief Act or the local COVID-19 related ordinance regarding evidence in some other way, believe state fact describing in the item 3T. This section is new making from the 1917. That's after COVID-19. This section is a new one. O. The property is covered by the Federal CARES Act, and the plaintiffs did not provide 30 days notice to vacate. Property covered by the CARES Act means for property where the landlord. Property covered by the CARES Act means property where the landlord. is participating in a covered housing program as defined by the Violation Against Women Act. Is participating in the rural housing voucher program under Section 542 of the Housing Act of 1949, or has a federally backed mortgage loan or a federally backed multifamily mortgage loan. B. Plaintiffs improperly applied payment made by defendant in a tenancy that was in existence between March the 1st, 2020, and September 30, 2021, as follows. Check all the apply. 1. Plaintiffs applied a security deposit to rent or other financial obligation due without a tenancy written agreement. B. Plaintiffs applied a monthly rental payment to rent or other financial obligation that were due between March 1st, 2020. 2. Plaintiffs applied of a monthly rental payment to rent or other financial obligation that were due between March 1st, 2020 and September 30, 2021, other than to the prospective months is rent without tenant's written agreement. Plaintiffs refused to accept payment from a third party for rental due. Civil Code 1947.3, Government Code 12.954.955. Q. Plaintiffs refused to accept payment from a third party to rent due. F. Defendant has a disability and the plaintiffs refused to provide a reasonable accommodation that was requested. S. Other defendants and objection are stated in item 30. 3T. T. Provide the fact to each dam checked above, either below or if more room needed in Form NC 025. Description of a fact or defendant are on Form NC 025, titled as Attachment 3B, 3T. 4. Other statement. A. Defendant vacate the premise on date. B. The fair rental value of the premise alleged of the complaint in excessive. Explain below, or if more room needed on Form NC-025. Explanation is on Form NC-025, titled as Attachment 3. B. C. Other specified below, or if more room needed on Room NC-025. Other statements are on Form NC-025, titled as Attachment 4C. 5. Defendant requested that plaintiffs take nothing requested in a complaint. B. Cost incurred in this proceeding. C. Reasonable attorney fee. Next page is 22. If today you're finishing the lesson, you're getting vacate, Christmas vacate. 2 weeks. Next week, after that, weeks, no, you don't need to come to the school. 2 weeks.
Thank you.
Okay.
Thank you.
And then you're starting for the January 1st weeks. January 1st week, so you can do it.
Okay.
That's the 2026 after 2 weeks. If you think that you go to the new year is good or not?
It's good.
It's good? Yeah. Young person is new year is good. Like me, old person is too bad.
Why?
Why? That's 1 more year. 2026. Wow. Okay. Page 22. 5. D. That plaintiffs is ordered to 1. Make repair and collecting the condition that constitute breach of the warrant or provide habitual premise, and 2. Reduce the monthly rent to reasonable rental value until the condition are collected. E. Other specific below or on Form MC-025. All other requested are state on Form MC-025, titled as attachment 5E. See, number of page attached. How many page attached? Unlawful detainee assistance. Normally, anybody getting this from unlawful detainee assistance, no. But if you get any information, number 7 must be complete in all cases on unlawful detainee assistance. Did not, normally did not. For compensation, give advice or assistance with this form. If the defendant has received any help or device for pay from unlawful detainee assistance, state A. Assistance name. B. Telephone number. 3. Street address, city and zip code. D. Count number registration. E. Registration number. F. Expiration date. Each defendant for whom is answered is 5 must be named in item 1 and must sign this answer unless defendant's attorney sign. First one is signature of defendant's attorney. Second, signature of defendant or attorney. Third, the signature of defendant or attorney. Verification. I am a defendant in this proceeding and have read this answer. I declare on the penalty of perjury under the laws of the state California and that the foregoing to and collect. signature of defendant, how many person, all the signature of the defendant. If this is just 3 lines, if more the person, just one page is attaching the page number UD-105, and then attaching 2 or 3 person, just date and name, you can do it. This is the answer, printed, a defendant answer. Okay, that's next page 23rd. 23rd is SEC 100, plaintiff's claim and order to go to small claim court. Small claim court is under $15,000. Under $15,000, you don't need any attorney. You can do by yourself. Just you can do court. This is the plaintiffs. I didn't get any money. In case this paper fill up and then to court file. In case after 1 month, you can do it. After 1 month, the other party should come to the office. If not, just a default, he lose the money, lose the case. If you don't receive that any working, if you receiving that any borrow the money, if you don't receive that any debt, you can see it. Sometimes somebody hit your car and he says that I gonna pay, I don't have any insurance, I gonna pay $1,000, and he didn't pay. In case you small claim court, you can do it by yourself, this paging. And then after that, he didn't pay, you can receive the judgment, you can file for the his bank account, and any his salary, and anyone you can take them. Small claim, you sure to remember that. You sure. That's important. Notice to the person being sued. You are defendant if your name is listed in 2 of this form or on form SC 108, the person suing you in the plaintiffs listed in 1 or 2 pages. This one is meaning plaintiffs making this paper and then deliver it to the defendant. Defendant is receiving this paper, and then normally after 1 month, in the date time, court time, if not going to the court time, they lose the case. You are the plaintiffs, must go to court on the trial date listed in below. If you do not go to court, you may lose the case. If you lose, the court can order that your wage, money, or property be taken to pay this claim. Bring witness, receipt, and any evidence you need to provide your case. Read this form and all pages attached to understand the claim against you and to protect your right. Aviso al demandado, this is Hispanic, the past, you don't need it. But in order to go to the court, this is scared. The people is 1 and 2 must attend the court. This one is making the court, date, time, department, name and address of court, if different and above. Quotes make a stamp for this section. Instructions for the person suing. Do not use this form to recover COVID-19 rental debt. This one, COVID-19 says that you don't need any rent if you pay the rent as good person. But the COVID-19 season, you don't need unpaid rent or other financial obligation under a tenancy due to between March 1, 2020 and September 30, 2021. Almost 1 month, you don't need the rent. To recover COVID-19 rental debt, use form SC 500, plaintiff's claim, and or there should be COVID-19 season is too bad, and then too low income, and then you don't need it, do not pay rent. You are plaintiff, the person you are suing is a defendant. Before you fill out this form, read the form SC 100 information for the plaintiffs to know your right. You can get form SC 100 info at any courthouse or county law library, or go to www.courts.ca.gov/forms. Fill out page 2, 3, and 4 of this form. Make a copy of all the pages of the form and any attachment, one for each party name in this case, and an extra copy for yourself. Take or mail in the original and the copies to the court clerk office and pay the filing fee. The clerk will write the date of your trial in the box above. Your court may allow electronic file. Check date local court website for information. www.courts.ca.gov/find my court form HTM. You must have someone else at least 18 years old, not you or anyone else listed in this case. Give each defendant a court stamp, copy all page of this form, and any page this form tells you attached. There are special rules for serving or delivering this form to public entities, association, and some business. See Form SC 104, SC 104B, and SC 104C. Go to court on the trial date listed above. Bring witness receipt and any evidence or needed to provide your case. If you are plaintiffs, you file to the court this paper, and then any other person, not you, any other person over 18 years old, any other person deliver through this paper to the other party. This is rule. Next to page 24. Number 1, plaintiff's name, business, or the person, business, or property entitled, and that the suing is. Plaintiff's name and telephone, street address, mailing address. Mailing address and street address normally same thing, just past. Email address, if you have, if not, the past is okay. If more than one person, one plaintiffs, list next to plaintiffs here, normally husband or wife, if other person, same thing, name, street address, same thing. Email address. If more than two plaintiffs and attach form SC 104A, if plaintiffs, one more person, one more page attached, next page, next section, check here. If other plaintiffs listed above the doing business under a fictitious name and attached below home. Third one, check here. If any plaintiffs, licensee, or deferred deposit obligator, payday, and lender, under financial code section 43 000 at Esquire. 2. The plaintiffs, the person, a defendant. Number 1 is plaintiffs. Number 2 is the other party, defendant. Name, street address, mailing address. If the defendant is corporation, limited liability company, or public entity, list the person or agent authorized for service for process is here. If the company name, address, check here. If your case in against more than and defendant, same thing. Number 3, the plaintiff's claim the defendant owes. Plaintiffs requested, defendant owe how much you should pay this amount. And then number 8, why does the defendant owe the plaintiffs money? For example, he borrowed the money he didn't return to me, or I worked that place and he didn't give me that any salary. And any, he damaged my car and he promised $1,000. After that, he didn't pay. Something like that. Any reason, number 8, any reason, so right here. Okay. Today is finished. You rest next week, 1 more week, and then see you next year.
Thank you.
Okay. Bye.
Thank you.